Good morning. Welcome. Today we'll hear oral argument in Canexus versus BNSF, docket number 42131. This case concerns a complaint that Canexus has filed asking the board to issue an order compelling BNSF to establish common carrier rates and service terms between North Vancouver and Kansas City and between Marshall and Kansas City. This dispute arises from BNSF's position that in the future it will carry the chlorine only as far as Spokane, Washington for movements originating from Marshall, and Portland, Oregon for movements originating from North Vancouver, where it will interchange with UP. Canexus and UP have objected to BNSF's proposed interchange points. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. First, while the board will make every effort to avoid soliciting information that is confidential in nature, if it becomes necessary to do so, we will recess at the end of the public portion of this hearing and conduct an additional in-camera proceeding for that portion of the argument. We have asked each party to make a short statement of its argument, but counsel should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all of your pleadings and there's no reason to repeat every argument. We have the following time allotments for counsel. The opening parties, Canexus and UP, have agreed to divide their 30-minute allotment of time. Counsel for Canexus will begin with 12 minutes on opening, followed by counsel for UP, who has requested 6 minutes. Counsel for BNSF will then have 30 minutes. Canexus has reserved 8 minutes for rebuttal, and Union Pacific has reserved 4 minutes. If you wish to make a change to your reserved rebuttal time, please advise us when you begin your opening presentation. Any party making a PowerPoint presentation or using similar hard copy aids using materials previously placed in the record should have provided these materials in hard copy size to 8.5-11 size to opposing counsel and the board. We will have any pages used today in such presentations bound into the transcript of this proceeding. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time that you have been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. In addition, just a reminder to everyone, please turn off your cell phones. We will now proceed. Counsel for Canexus, please step up to the podium, introduce yourself for the record, and begin.
Good morning. My name is Thomas Wilcox. I'm here on behalf of Canexus, the complainant. I'd like to introduce a couple of client representatives who are here. We have Mr. Marty Cove, who's the manager of logistics for Canexus. He came in from Vancouver. And we have Ms. Diane Petty, who's the vice president, general counsel, and corporate secretary, who is from Calgary. I do not intend to introduce any confidential information, so I don't think that'll be an issue, but I'm sure my clients will let me know.
Could you speak up a little bit, please? Not, or right into the mic. Thank you.
Is that better?
Yes. Yeah.
Okay. I don't plan on introducing any confidential information, but I'm sure they will let me know. To begin, Canexus would like to thank the board for its actions in the case so far. You've been timely, you've been proactive, and you've allowed service to continue to these customers pending this dispute, and Canexus appreciates it. This is a straightforward case, and it's whether BNSF is legally obligated to maintain common carrier rates and service terms from Canexus facilities in North Vancouver and Marshall to the Kansas City interchange. The underlying facts have been developed in a pretty full record, but the salient fact is that prior to 2011, BNSF had no problem hauling Canexus's chlorine long distances and interchange with UP for further movement by UP by contract, and that included the Kansas City interchange where they had rates in place. The BNSF unilaterally decided in 2011 it would adopt a position for TIH commodities where BNSF, quote, is entitled to the short haul when BNSF does not serve the destination. Canexus learned of this position in 2011 while it was simultaneously making its transportation arrangements for 2011. And UP's preference for these particular movements was to enter into a contract with Canexus from the Kansas City interchange. It was consistent with prior practices where BNSF had common carrier rates and UP entered into contracts with Canexus. Canexus was caught in the middle of this to some extent, but believes it and UP acted reasonably in entering into a contract for the transportation from Kansas City, and that BNSF violated its common carrier obligation by not supplying rates, or by not first refusing to supply rates, but then now has taken the position that they want to only establish temporary rates that they want to terminate and only go to Spokane and Portland.
How long has BN been delivering the chemicals from Vancouver to Kansas City for the change? When did it start? When did those shipments begin? Can you tell us that?
As I understand it, there was a rate in place in 2010 to Kansas City for interchange with UP that was not used. I believe that's correct. It was not used, or used not very much. However, there were shipments made between January 1, 2011 and March 16, 2011 using that rate and a common carrier rate that was temporarily in place with UP while they were still negotiating the contract.
So this is a relatively new movement then. It's not something that's been going on for like 10 years or so, and now all of a sudden there's been a change. Is that correct?
I believe that's correct. But
your filing says there were 18 carloads in January to March. And then when you filed your first submission in May, had there been any since the March time until May when you filed, or were there just 18 that had occurred before you came to the board?
There were 18 before Canexus came to the board, and there's been.
Did you ship to these shippers prior to 2011? And if so, how did you get your products to them?
I don't know that that's in the record how that was done. I can ask for clarification from Mr. Kof if you'd like right now.
Yeah, I'm just trying to understand if it's just a convenience of how you're getting it through Kansas City, or if you had not ever shipped to any of these customers before.
Mr. Kof, if you'd like to approach, you can. You probably weren't expecting this today.
Yeah. First, to answer your question, between March and May, we were continuing to ship over the Kansas City interchange. There was a brief period of time when there was not a rate available to us, so we were using other interchanges that BN objected to, and quite rightly so. But BN then agreed to put a new rate in place with a limited time horizon.
Could you clarify when, or Mr. if you want to clarify, when was the rate not in effect?
There was a period of about 10 days where the rate had expired, and where
is this at pre-May or post-May?
This is in March.
Okay.
So the rate had expired on March the 15th. And there was a period of time in which there was no rate in place to Kansas City. And it was about 10 days later that BN agreed to put a rate in place temporarily until the end of June.
And could you give me a sense of, since the January to March of the 18 shipments, how many shipments you've shipped for the year of 2011? Just to or maybe tell us later and confidential.
Okay, yeah, I'll tell you later.
Okay.
It was dozens, though.
Okay.
Prior to that time, now we're going to get into a lot of complexity. The nature of our business is we're a very small producer. We account for less than 1% of the chlorine that's sold in the marketplace. So we are certainly not large enough to say dictate pricing or have a large control over the marketplace. We are essentially following our other competitors and trying to fill niche markets. In particular, we tend to be largely in the water treatment marketplace, not strictly, but typically. And our ability to find customers is often quite complex. So we're constantly changing our customer base in response to market conditions. Prior to, let's say, January 1st, 2011, Canexus has shipped over a variety to a variety of customers over a variety of corridors, including Kansas City. I don't have the exact numbers available. I'd have to go back and look at my database. It wouldn't have occurred often, but it definitely has occurred. There are some customers actually in Kansas City itself that we have served in the past through BNSF, but I'd have to go back and check my data to give you a more definitive answer on how often we've shipped through that corridor. Does that answer your question?
I think so, for now.
How am I doing on time after that?
I don't know, timekeeper? 4 minutes.
Okay. Well, I only have 3 points to raise, and I will try to get through them quickly since you do have a full record ahead of you, or in front of you. The refusal to provide the common carrier rates necessarily requires application of the board's principles and rules that came up in the Central Power and Light cases on what is the appropriate interchange point. And
do you think, I mean, with respect to that, that this is a 10705 case, though?
Well, those cases did involve, to some extent, the routing preference under 10705A2. The board was balancing the routing preference of that statute versus the contracting statute. And that's, in fact, the D.C. Circuit that's came up in the FMC case when the FMC case was affirmed by the D.C. Circuit. UP in that case tried to make a similar argument and said that the routing preference takes preference over the contracting preference, and they even called it jurisdictional stripping because it took away the long haul. And the D.C. Circuit rejected that, and the site is at 202 F3rd 344, where they said that the CPL decisions that talked about this balancing of where the long haul preference has to be balanced against the destination railroad's preference to enter into a contract. They said the board's discussion was lengthy and well-reasoned explanation of the intersection of the conflicting mandates of its contractual and long haul provisions. And so this has come up before, and
in that case, wasn't it really dealing more with the rates as opposed to the routes? That they were entitled to get a rate to a certain point and to divide that rate so that they could get a short haul or on the bottleneck, a rate on the bottleneck also?
The routing was still an issue. I mean, the board, the court, and the UP wanted it all. They wanted the whole route. They didn't want to divide it up, and so they wanted the single line haul, and so they still made these similar arguments.
So going back to my original question, I mean, do you still consider this case a 10705 case or some form of hybrid? Because no one was real clear in their briefs about the statute that we would be relying on.
Well, it's in terms of choosing the interchange point, it's 10742, and the board in the CPL cases said this is a statute that is used for other things, but it's a statute that will apply here in terms of coming up with the criteria for the interchange points. I'd say it's a hybrid because in our view, once you establish the interchange point and you have a contract, and we believe the FMC case raised the significance of the contract in the analysis, but once you have those things, then the carrier from the origin has an obligation to supply a rate under 11101 to that interchange point. So
wasn't the FMC case, though, the interchange wasn't in dispute, so it was already a settled matter?
Well, I think that there is a UP did not, as in here, object to that interchange point because been used, but I don't think it's that much of a difference, because here BNSF doesn't dispute the efficiency, the operational feasibility, anything about the Kansas City interchange point, just doesn't want to use it. So I think there is I'm not saying there's no difference, but I don't think the difference is very significant.
Thank you.
I'll try to reach my other 2 points on rebuttal.
Okay.
Although it will be hard for me to reply.
That's true. Do you want to take a little more time? I know we've asked a lot. We'll be flexible with respect to time. This is a very important case.
Actually,
just so at least you can hit your 2 points.
Yeah, actually
and I'll lay off.
No, as a matter of fact, I think I've actually hit them, because our second point was that 10705 does not give a unilateral preference or a preferred preference to the origin carrier, that those are balanced. So I've made that point. The third point was just that from a policy consideration, in terms of overall policy, there's no issue here about shippers, this shipper in particular, or in general, trying to dictate the routings of TIH movements or doing backroom deals with railroads. If you look at the facts, surely belie that. There are other policy issues, which are whether the board's going to allow these carriers to short haul TIH movements and negate contracts that are valid and valuable to the shippers and to the railroads.
This is a very different case in the sense that the railroads here are desiring to short haul themselves, whereas typically railroads do not want to be short hauled.
Well, absolutely.
Decision. So that's a unique part of this case. One other thing, though, on 10705, we talk about reasonable preference to the originating carrier. We also talk about other factors such as adequacy of service, efficiency, etc.
Mm-hmm.
Do you think the board has other factors that should be taken into consideration, such as length of haul or population exposure or other things in deciding which carrier should have it? Should it take into account these public policy issues, or should we limit ourselves to what's specifically listed in 10705?
Well, I think that in this case in particular, you have a case where BNSF is saying they want to short haul themselves. You should give them that preference. But the only reason that they want to do it is because they want to minimize the risk to BNSF. But that, as UP has pointed out, that's just foisting risk onto UP and to other railroads with no consideration of what the alternative movement's going to be. This is an efficient movement, and it works. It has worked. And it's I think as far as looking at a reasonable preference in the TIH movement, you should look at what's the alternative. BNSF is not. They basically said, well, any alternative other than us is what you should do. Now, there are difficulties with that because the routings are not, for TIH routings, they're not public. We don't know how BNSF gets the chlorine from North Vancouver down to Kansas City. We don't really care, obviously, but of course we care from a public safety standpoint, but in terms of how they run their railroad. Anyway.
Okay, thank you.
Okay. Thanks for the extra time.
Good morning, Chairman Elliott, Vice Chairman Mulvey, and Commissioner Mulvey, or Begman. I'm going to depart from my prepared remarks and go to where I discern the interest is. So I will try to clarify the movement history, and then I will try to clarify the law that we're relying on before getting to my summation. Fundamentally, Canexus has 7 destinations to 5 states that are at issue in this proceeding. 2 of those destinations previously received chlorine moving BNSF UP, but not via Portland, Spokane, or Kansas City. They received it via Chicago or Dallas-Fort Worth. The other 5 are new destinations in accordance with, as Canexus indicated, they're reaching out to new markets. So a lot of the data that we provided in terms of what the past practice, what the past routes have been, basically we're looking at both all of the traffic that BNSF was originating or handing to us in the Pacific Northwest, moving to the first 3 states that were at issue, and then also looking at what the TIH. And when you look at all of the traffic, it's clear Kansas City, while not the most common, was one of the most common interchange points for traffic that was flowing here, and it actually did move some TIH, although TIH altogether is something in the neighborhood of 1% of the total traffic interchange between BNSF and UP. So in that sense, the first, at least in recent history, BNSF, Kansas City, UP movements would have been in January, moving under a previous BN group rate plus a UP point-to-point proportional rate. But as far as we can tell, that traffic began moving in mid-January. So that is the movement history as we understand it. And then stepping back, we do have a lot of Portland traffic now being interchanged, but UP has agreed to that for Western destinations. So
is that TIH that's being interchanged there?
This is all chlorine and all TIH.
Okay, sure.
But basically, the distinction we are drawing is that you have to look at the suitability of both the interchange where the physical handoff occurs, as well as what the entire route is going to be. And so while we may have thought it was foolish for us to say, even though BN had been handling the chlorine to Stockton and Colton before giving it to UP for a short haul, we thought it would look very strange for us to say it was unreasonable for us to take it in Portland instead, although we were obviously happy with the Colton and Stockton interchanges. But that's for Western destinations. When you're talking about moving traffic into Arkansas, Louisiana, or Missouri, Portland looks to us to be a very unusual interchange to be using for that type of a move. And so that's why we said, look, we're going to be looking for a different interchange, and Kansas City seems to be centered relative to these destinations, and it is a commonly used interchange overall, and it has in fact moved TIH. Both railroads are open to doing a TIH interchange in Kansas City. So I hope that helps clarify what the movement history.
What if the roles were reversed here, and you were the originator of the traffic? I mean, would you want BNSF telling you where the interchange point would be and where you had to run it?
UP's position is that both the originating road and the terminating road have a vote, that neither road gets to dictate to the other. And our objection here is that BNSF had a right in its business judgment to choose to change its strategy from a group rate structure and going after the long haul to say we want to do point-to-point rates and we want to have a short haul. But they don't have a right, having decided that that's their strategy and that's where they want to be. They don't have a right to then dictate to their connecting carriers, therefore you will take this in a city that has not been used as an interchange for this type of traffic. They need to reach an agreement with us, and if we can't work out an agreement, then we would get back to this.
So do you think, I asked Mr. Wilcox this question, do you believe that this case is a 10705 case, strictly with respect to the route?
In part. We believe that there are several statutory provisions that come into play. 10701, 10703, 10705, and 10742. If you put those together, the principle is carriers are the ones who are supposed to establish the rate, and they're supposed to do it by agreement. If they cannot agree, then the board, under 10705, does have the authority to prescribe a through route. Under 10705A1, that route is supposed to be in the public interest. Under 10705A2, there are several considerations that are put in there, and as a tiebreaker, there is a provision in the long-haul law that the origin carrier reasonable preference should be granted.
So you think that only applies with respect to the long haul, or do you think it applies to 107.05A1 and 2?
I think that this is a very unusual case because it's maybe the first time ever that 107A2, which was designed to protect the origin carrier's right to a long haul, is being turned around as turned into a fiat, according to how we read BN's pleadings, that the origin carrier gets to decide and overturns all of the other law that says in the first instance the connecting carriers are supposed to reach an agreement.
Yeah, this is a very unusual case in the sense that in most cases railroads want traffic and they want revenues. Here, neither railroad wants the traffic or the revenues, even though it's very, very likely that whoever gets this traffic in the long haul will probably be better off from an economic sense, providing, of course, that there are no mishaps along the way. There haven't been any mishaps since the one we had, a very, very serious one in Graniteville a while back. But for the most part, TIHs have moved safely. But since one of the issues is exposure, there's two factors in exposure. There's population, and then there's also length of haul. And the proposals that BN has come up with, interchanging in Portland or interchanging in Spokane, that would change the exposure, will exchange the populations that are at risk, and it would also change the length of haul that this material is going to move. Now, we don't know what the exact routing is going to be, but we can make some reasonable estimates as to what they would be. Do you think that the length of haul that's involved and the population size that's exposed should be factors in determining how the board should make a determination as to how this traffic should move?
I would say clearly those are relevant factors. They're among the 27 that we are required to consider under PHMSA in coming up with what a route is. Mm-hmm. What I would say is based on the record we have here, we know that both BN, because it has admitted UP's characterization, has said that routing this via Kansas City is a feasible and a reasonably efficient route. Mm-hmm. We're not sure that Portland is, because we're not sure how BNSF would move it via Portland. And we are fairly confident that we believe that Spokane is not a suitable interchange, because one of the other factors you ought to consider is where you're doing the handoff is how often do the carriers do it? Is it part of their ordinary course of business? Both carriers hold themselves out as accepting and receiving TIH from each other in Portland and in Kansas City. BNSF has published a restriction that says, no, we don't accept it. Don't bill it through Spokane unless you call us first, and then we'll make arrangements, which to our mind is a disqualifier for using Spokane as a movement. But I would say that aside from the risk, which is obviously a major consideration, but we try to deal with the risk in a variety of ways, but one is obviously short hauling, but obviously 100% of the distance has to be covered by some combination of carriers. Ultimately, there is no way of everybody being able to do the short haul, but it's still rational for a carrier to pursue the short haul. We believe that there are other factors as well that may be motivating BN's decisions. We know that we take it into consideration, and one is how much investment are you going to have to make in PTC? And to our mind, it makes sense if you're just looking at it from a very top-level view. If you're looking to minimize the amount of PTC investment that has to be made, it makes sense for the origin carrier to have a longer haul as opposed to the destination carrier, because there are fewer origins than there are destinations. So just looking at it from the terms of the network, if a factor you're trying to take into consideration is minimizing the incremental PTC investment, then that would tend to point you in the direction of the origin carrier taking the long haul. But UP is not even insisting on that. We think it's too complicated, and that what makes sense is for the carriers involved to sit down and develop a TIH routing protocol if, in fact, they're saying, you know, the way we've historically routed this isn't making sense in this regulatory environment, and we ought to make adjustments, the carriers ought to be talking about it.
Why can't the carriers get together on this? It seems like, from what I've heard since I've been chairman, you guys don't want us regulating your business, and here you are asking us to pick the interchange. Is there any way that this can be worked out?
UP is willing, and we renew our invitation to BN to discuss a routing protocol. We believe that what happened here is that there were changes in business decisions by 2 of the 3 parties. Canexus decided that they wanted to ship to some origins that they hadn't shipped before, as well as shipping to some origins, let's say east of the Missouri, that they had shipped to previously. BNSF made a business decision at the end of 2010 that they wanted to go for a short haul, that they wanted to drop their group rate structure and go to point-to-point rates, and that presumably, therefore, or as a result of those, they then said the way this traffic has been routed in the past doesn't make sense under our new strategy. We want to do new routes. And they have a right to make that business decision. What we're saying is, when they made that decision, and when it became apparent that the way the traffic had been routed wasn't the way they wanted it to route in the future, they should have told UP and initiated a dialogue. And that didn't happen. We didn't know about this business strategic decision of BNSF's until June 15th, when they filed the response in this proceeding.
You mentioned that there are 27 factors that need to be considered in deciding how to route this. And one of the concerns that I have is that if indeed the board winds up de facto making these interchange decisions because carriers can't agree on the long haul and short haul for TIHs, that there are all these factors and how we would weight individual factors. I sort of envision this giant mathematical model where you have weights applied to each one of these, and then it comes out and says, okay, this is 47.6 versus 47.2. Therefore, it's a very, very complicated process, and I'm just wondering, that can't be what the railroads are interested in doing, have the board make these decisions. One would expect that the railroads would prefer to make these themselves. Is there any way of facilitating discussions between the railroads so that we can avoid having this issue come before the board again and again?
I absolutely agree with you, Vice Chairman Mulvey, that it's not a good use of the board's time, and it's probably not the best way of coming up with what are the optimal or the best overall routing decisions to be made, that really ought to be left to the railroads. I believe that if you decide in this proceeding that Kansas City is in fact a reasonable interchange at this point based on this record, that basically sends a signal to railroads, whether they're the origin railroad or whether they're the destination railroad, that unless you want to be like where I am here today, that they ought to sit down with each other and talk about it based on all of the operating data, all of the other data that they have available to themselves. And hopefully we would be able to reach agreement in all circumstances, but in certainly the majority of the circumstances, so that we could, one, reduce or eliminate the number of times an issue like this would have to come to the board and a poor TIH customer would get involved in the crossfire. And secondly, when or if any such disputes did end up at the board, that you would have a clearer record and we would be basically eliminating opportunities and saying, okay, here's the clear example, or here are the factors that are dividing the railroads about why we think, this railroad A thinks that this route is better and railroad B thinks an alternative route is better, so that it would be at least clarified, if not completely avoided.
Can you help me understand how, if such a decision from the board, as you suggested, which would be to suggest that Kansas City would be the reasonable interchange, how does that not send a signal that for TIH, all current routes are locked into basically the map that's existing today, not 2008 map, but the January 2012 map? How does that allow flexibility?
Now, needless to say, I cannot speak for all railroads. I can only speak for my railroad, Union Pacific. But I will say that UP did not say, thou shalt not change any interchange period on the Canexus traffic. In fact, once we were engaged in contract negotiations with Canexus late last year and as they extended into May, and we could discern that BN liked Portland a lot, we in fact did agree for the majority of traffic that Canexus is routing BNSF UP today, that instead of continuing to receive it in Colton in Los Angeles and Stockton in California, which was a BNSF long haul and a UP short haul, we have agreed to accept it in Portland and accept the long haul. Because I said, as I understand the law, you need to be able to reach an agreement, and if you can't reach an agreement, you better be prepared to go before the board and explain why you were reasonable in insisting on the existing interchange or a different interchange. And I didn't feel comfortable defending an insistence on Colton so UP could get its short haul, which is just as rational, I submit, as BNSF wanting a short haul. But I didn't feel comfortable defending that as a reasonable position. And therefore, we adjusted, and BN got its short haul. Where we drew the line is where it appeared to be BNSF always gets the short haul with this customer without regard to the entire circumstances and the entire route. So that's a long way of getting back to, I would hope that other railroads would look at this situation, not want to repeat the situation, and say, I better reach an agreement, and if I can't reach an agreement, I better be prepared to explain why I'm being more reasonable than the other fellow.
In the BN is proposing two new interchange points, Spokane and Portland, to interchange rather than going to Kansas City. Are you aware, or do you know that there is a difference in the total miles that this material would travel from those 2 points as compared to Kansas City? And that what if there were a difference that in one case the total amount of miles was longer through Kansas City and the other one was longer through Portland or what have you? Do you think we could bifurcate this so that some of this traffic might go via UP interchange points in Washington State and in Portland versus other traffic going directly to Kansas City? So
we would certainly be very agreeable to example for saying that, say, the destinations that are more southerly, if that got routed via Dallas, Fort Worth, or Houston, as opposed to Kansas City, we'd be willing to do that. And if the ones that were further north either went through Kansas City or, Chicago has been common. I don't know because I don't know all of the data. That I would say that Chicago would be the better one, but we are certainly willing to discuss that. And, that's, to our mind, the benefit, the virtue of having a routing protocol is that you're approaching this objectively and scientifically using the data to be making decisions.
Thank you.
Why don't we hear from BNSF now?
Good morning, Chairman Elliott, Vice Chairman Mulvey, Commissioner Begeman. My name is Sam Sipe. I'm outside counsel for BNSF Railway in this matter. With me at the counsel table is Richard Weicker, Vice President and General Counsel Regulatory for BNSF. And Mr. Weicker is available to answer any questions the board might want to put to a company officer of a policy nature. BNSF appreciates the board's commitment to moving this matter towards resolution on an expedited basis. And in particular, we appreciate the board's representation that it would try to resolve this matter by January 31st. In that connection, BNSF wants the board to know that BNSF is still hopeful that it will be able to resolve its disputes with Canexus without the need for a board decision. As you know, there's a second dispute between the parties, that is BNSF and Canexus, involving rates from North Vancouver to the southwest that is not before you today. That dispute, which is being adjudicated under the board's 3 benchmark procedures, is the subject of a mediation between Canexus and BNSF this afternoon. And BNSF will be participating with business representatives in that mediation. We've reached out to Canexus in advance of the mediation and indicated that we're hopeful the parties can explore the full range of issues that are outstanding between them and perhaps resolve the dispute in both the routing case and the rate case. We have no way of knowing whether such a resolution could be accomplished this afternoon, but we hope the mediation will be at least a first step in moving towards a comprehensive resolution of these issues. And we will, of course, keep the board advised of any progress, and we will respect the confidentiality of this afternoon's mediation as well. As to the current dispute, I want to emphasize at the outset that this case has never been about the issue of whether BNSF will provide service to Canexus. The actual issue before the board is a relatively narrow one, and I do regret the fact that the parties have not been able to, the parties being UP and BNSF with Canexus's input, were not able to resolve the matter of the interchange before this came before you. And there's been a fair amount of discussion about that, and I could add my views on how that came to be. It's not an optimal situation. We don't want to be in the business of bringing these matters before the board, and we will strive not to bring them before the board in the future. But here we are, and we think the issue before the board is a relatively narrow one, and that's to determine the appropriate interchange point for Canexus's chlorine. We believe that the Spokane and Portland interchanges are rational under the circumstances of this case, and that the statutory preference for the origin carrier carries heavier weight than the other factors that have been introduced on the record of this case.
Are you actually an originating carrier? Because my understanding is that BNSF, in fact, is a bridge carrier, that you don't actually pick it up at the manufacturing plant, but rather that's a Canadian railroad, and then it's transferred to BNSF, which sort of makes you a bridge carrier instead of an originating carrier, and that, of course, might work against the reasonable preference for the originating carrier. Do you want to comment on that?
Yes, it's a very relevant question, Vice Chairman Mulvey. Physically, we are not the origin carrier. Canadian National switches the traffic to us, and we handle it for purposes of the statute. We handle it from the CN switch outside of North Vancouver. For purposes of the statute, we believe we clearly should be treated as the origin carrier for 3 reasons. First of all, in terms of the line haul movement for which we establish a rate from North Vancouver to wherever it is, Portland or Kansas City, in terms of the line haul movement, we are the origin carrier, the first carrier in that movement. Second, in terms of the board's jurisdiction over this dispute, we are indisputably the carrier that originates the portion of the movement in the United States. Also, we are the carrier that Canexus asked to handle its traffic, to move it from North Vancouver, whereas they could have routed this, presumably, they could have routed this traffic via CN, which has the physical origin. conceivably, they could also route this traffic via CP. There's been discussion on the record about whether CP would be willing to handle the traffic, but BNSF is the one that Canexus chose. So for all three reasons, we think when you read this statute, you should treat us as the origin carrier in terms of the preference. And while I'm on that point, let me just respond to the question that Chairman Elliott has put to both the other counsel of whether this is a 10705 case. And I think I'm more or less in Ms. Wren's camp, and to say in part, in the second bottleneck decision, the board spoke about routing and interchange decisions in the context of the overall bottleneck issue, which, as you know, was an issue regarding competitive alternatives. And when Chairman Elliott asks, is this a 10705 case, I think what he's asking is this a 10705 case for purposes of seeking relief, the prescription of an alternative route under the competitive access rules? Clearly, it's not a 10705 case in that sense, not an alternative route. But the bottleneck decision addresses 10705, and it speaks to the issue of how the board decides an interchange dispute, even if it's not in the context of a competitive issue, like a true bottleneck case. And it says the normal practice is the carriers agree. They have to come up with at least one route to complete the shipper's needed multi-carrier service. Accordingly, if the carriers cannot agree on an interchange that would act to create that route, we will determine one. That determination would not involve the competitive access regulations. So both the statute and the decision speak to this issue, the broader issue of what do you do about an interchange point.
So just so I understand, with respect to 10705, I wasn't specifically referring to the competitive access rules with respect to that. I was just looking at the statute itself and the analysis that was required under that statute. And kind of what I'm hearing from you is that you're applying some of these aspects to it as far as being the originator and some type of preference, which comes from that statutory language. Is that kind of?
That is correct, Chairman Elliott. And the other thing I'm wanting to do is distinguish my position from Mr. Wilcox, who says he takes it further under the board's reading of 10705 in the bottleneck decision and says BNSF is the bottleneck carrier, and for that reason you should give conclusive weight to our transportation contract with UP. And that's clearly wrong. I mean, the first part, that our situation speaks to 10705 and implicates that section of the statute and the preference for the originating carrier, is clearly correct. But the second proposition, that somehow we are a bottleneck carrier and therefore the Canexus contract with UP basically trumps the statutory preference.
I'm not sure whether
that's not right.
If it's trumping or not, because BN has called the UP Canexus contract irrelevant in this dispute, and I think you've pretty much made the same point just now. But how can a contract play no role at all in the board's determination on this issue? And don't we have the obligation to try to harmonize one carrier's contracts with another carrier's routing preferences? Isn't that the board's job to make those, to balance those interests, as opposed to, say, well, reasonable preference is the only thing we should be considering?
It's hard for me to know how you give weight to the contract in this circumstance, Vice Chairman Mulvey, unless you treat it sort of like a wild card in poker. And you say, okay, for this hand, in this hand, I'm going to say contracts, you can turn a contract into an ace. The contract here, for purposes of this dispute, has no content other than to tell us these guys have agreed to Kansas City. We know nothing else about it. It doesn't flesh out any factors regarding the efficiency of the movement. It doesn't tell us anything about the market for chlorine. We don't know anything about the terms at all. The board doesn't know anything about the terms at all.
But it is true that there is other factors that need to be considered in addition to the giving the reasonable preference to the originating carrier. And in fact, the term reasonable itself would sort of imply that other factors ought to be considered as well. Would you agree that in the board making a determination in this case, if we have to make the determination, if the carriers can't reach agreement, and as it comes to the board, that we should consider public interest factors as well as the rights of the originating carrier under 10705?
I would say that both the statute and the bottleneck 2 decision that I have been referring to suggest that the board should consider other factors. I would also suggest that under the record, given the record that has been made in this case, you are somewhat constrained in your ability to consider other factors because the parties have not made a comprehensive record on other factors relating to some of the considerations you've talked about, such as length of haul, population densities, other factors involving safety. I won't speculate on why that record hasn't been made. I will say that you may appropriately feel a little bit hamstrung because the parties have not made more of a record as to those factors. And what we're saying is, given what you've got here before you, which is not nearly as much, for example, as you had before you in the energy case when you were considering the prescription of an alternative through route. Given what you have before you in this case, the best thing you've got is the statutory preference, and it fits. And you, Vice Chairman Mulvey, have alluded a couple of times during this oral argument to the fact that we're dealing with a situation here involving the transportation of chlorine in which the normal incentives and preferences are flipped on their head. And, you know, that may sound peculiar when one thinks about fashioning a rule of law. And yet everybody understands perfectly why these normal incentives are flipped on their head. It's because the uncertain and unquantifiable risk of a disaster exceeds the tangible benefits of hauling this chlorine for relatively high rates. Managers don't want to incur even a very small risk of a disastrous outcome. And that influences behavior regarding the transportation of chlorine. And I don't think anybody in this case has suggested that BNSF's aversion to the long haul is irrational or unreasonable. And Ms. Wren has candidly acknowledged that UP would rather have the short haul. Indeed, UP did have the short haul on those movements to California before the route was changed to interchange at Portland, and she would have preferred if it had remained that way.
The railroads have made it very clear that they really don't want this traffic, but have to carry it under their common carrier obligation. And we've heard that from various speakers in the past. It's on the public record. But let me ask you a question and follow up what Commissioner Begeman had raised before on Spokane. At Spokane, BN has a notice that it will not take TIH without prior notice. And can you explain why they have that rule at Spokane, or what is the basis for that?
I'll tell you what my understanding is about Spokane. We proposed Spokane to handle these movements from Marshall, Washington. And the history behind Marshall, Washington is that Canexus established it back around the time of the Vancouver Olympics as basically a staging area for its movements of chlorine. They wanted to get the chlorine out of the Vancouver area during the Vancouver Olympics, as I understand it. So the idea was that they would bring it over to Marshall, Washington, and then when it was ready to move to further destinations in the U.S., they would ship it out of Marshall. It was supposed to be, in my understanding, a short-term solution for a low volume of traffic. And I believe we have said in our papers, without quantifying the movements, that the movements out of Marshall are a very small portion of the Canexus traffic handled by BNSF. The majority of it is out of North Vancouver. So Spokane is, in fact, contrary to Portland, not a place we normally interchange chlorine with Union Pacific. And so we have, because there's not a standard practice, we have this basically notice provision. And when we're bringing chlorine to you in Spokane, or vice versa, although I'm not aware of any vice versa circumstance, we got to call up and make sure we've got the right personnel there, and we arrange to handle this material safely. And contrary to Ms. Ryn's position that this sort of illustrates the inappropriateness of Spokane, I think it's entirely appropriate that if you have very rare shipments of a commodity that needs to be handled with special care, you make special arrangements to handle it. I don't think there's anything in the fact that you've got to make a phone call and arrange to have the right people on the premises that makes that disqualifying as far as Spokane is concerned.
Given the railroad's interest in short hauling TIH, I think that's sort of how you described it, and Vice Chairman Mulvey also raised it. Are there other examples where BN has done just that besides with the Canexus shipments? Or is this sort of a first effort to do that?
We described in our June 15 pleading, Commissioner Begeman, a change in both routing protocols and rates that BNSF undertook with respect to its TIH and chlorine, including chlorine traffic, back in last March. It was a kind of watershed period in terms of the companies thinking about how are we going to deal with this TIH. Prior to last March, as I understand it, we had what Ms. Ryn has referred to as a regime of group rates, which allowed shippers and connecting carriers considerable discretion in where they would accept the traffic. And we found that we were basically getting long-hauled and sometimes getting long-hauled via irrational and circuitous routings, which compounded any disadvantage. And under the new point-to-point rates that we instituted, we tried generally to reduce the flexibility of shippers and connecting carriers to saddle us with the long haul. That's about as specific as I can be about shippers other than Canexus. As to Canexus, there's more information in the record, and basically what that says is our policy is that the carrier who hauls this Canexus traffic that we participate in to destination should get the long haul. And in 70% of the cases, that's us. We're not adverse to fulfilling our common carrier obligation, and we do. We take it to distances a whole long way from North Vancouver, including the two destinations that are involved in the 3B rate case that I referred to earlier at the outset. Albuquerque, New Mexico, and a point in Arizona. Local BNSF movements, we take the long haul. On the movements where we can hand it off after a short haul to a carrier who serves the destination, we instituted this practice of saying, we're going to give it to you at the nearest workable junction point. In addition to the UP movements to California, which fit in that paradigm, we also had a CP movement to St. Paul, Minnesota. And Canexus, this is in the record also in our June 15 filing in Mr. Guerin's verified statement. And Canexus was saying to us, hey, would you guys take this to St. Paul and hand it off to CP, where they can take, they serve the shipper and they'll take it into the shipper's facility. And we said, wait a minute, does it really make any sense for us to take this traffic all the way to St. Paul when CP could take it after a relatively short haul? And Canexus agreed no. So that's an example of how the policy we have implemented of stepping up to our obligation to take it all the way where we have to.
Let me ask you about that policy. I think, just so I'm understanding, especially I think it was kind of what the commissioner was getting at. With respect to this case, I mean, are we specifically saying the policy only applies with respect to Canexus traffic?
Yes.
Yes. So where does that leave us after this case? Let's say we buy your argument in this instance, and then after that, it leaves us wide open for a case-by-case analysis. Wouldn't it be better for us to come up with one policy across the board, across the system? I kind of compare it to having each state coming up with their own laws as opposed to federal law ruling the whole area.
I certainly think one could make the argument for coming up with a comprehensive set of principles that should govern from the board's perspective the routing of this TIH, ultra-hazardous traffic. But I think it would be really a bad idea to try to get there through the vehicle of this individual dispute. I mean, there are multiple reasons why you would, if you were ever to adopt such broader principles, you would want to do it on the basis of a broad record that allowed all participants, all interested parties, the opportunity to participate. And you would also, and this gets really complicated, I'm afraid, you would also need to take account of these other regulatory regimes, FRA principles, PHMSA, the obligation to install PTC. And Mr. Weicker, by the way, is much more knowledgeable about these than I am because he's involved in compliance with and implementation of plans in response to these multiple regulatory regimes. So the board would want to approach that broader objective, Chairman Elliott, which I think is a laudable objective, with really great care and make sure you chose the appropriate vehicle.
If I look at it specifically with respect to this case on the point-to-point, what is the BNSF's rationale behind that, why that's the more reasonable method to use in this instance?
Well, it works. If people adhere to it, it works. Canexus gets its chlorine, and we do, as I say, our share of the work by taking all these long hauls to the 70% of Canexus destinations where we serve the destination, and the other carriers who are in the route of the interline movement don't get a free ride. Now, you heard Ms. Rinn say that as to the Canexus movements into California, she could understand the case for BNSF getting the short haul, and she didn't want to be in a position of saying that UP should insist on the long haul for BNSF into California on Canexus movements. But she said she felt differently about Kansas City, and I certainly respect that. I have great respect for Ms. Wren, but I really don't understand what led her to the different conclusion there, because it seems to me that the principle that would have caused her to say it's appropriate for BNSF to short haul itself over Portland for movements into California, but not to do the same thing for movements elsewhere in the country. I don't understand the principle there.
You say it works. I mean, that doesn't really seem like
it works, except in this case.
But I mean, you said
it almost worked.
Your point to point, you say it works, and I understand that it works, and I assume you agree that the Kansas City interchange point also works because it's been used. Is there something grander than that? That why this is a better method for choosing points of interchange as opposed to just that it works? Is there safety concerns? Is making the destination for you better?
I'm always for the grandest possible rationale, and I've looked hard for the grand rationale in this case on both sides, and I don't want to denigrate any of us, but I'm not sure that we've achieved the grand rationale. We have a statutory preference here. I think it fits the circumstances, and that may be less than the board would want to have as the basis for deciding the case. But it is a basis, and it's the best basis here. And let me just say, I think I'm probably close to the end of my time. Let me just say one last thing, unless you have further questions about the bottleneck business we went through earlier, and want to make sure you understand why I think Canexus and Mr. Wilcox are just wrong when they try and shoehorn this case into that box. And by the way, UP agrees. If you look at their footnote in their rebuttal filing, which takes issue with Canexus's reliance on the FNC case. The last point I want to make is there is a danger here in the board ruling for Canexus on the basis of this contract. And the danger is that that could be construed as a precedent to allow shippers to control routing of these TIH materials. And Mr. Wilcox said in his filed papers, the board, he said, the board can ignore that it might be a dangerous precedent. Well, I don't think so. I mean, a dangerous precedent can't be ignored. And I don't know what people would make of that decision. But the record and the positions that Canexus has taken in this case stand for the proposition that the shipper ought to be able to determine how the railroad routes the traffic of this ultra-hazardous material, which is clearly inappropriate.
When you say the shipper controls, I mean, doesn't that follow, though, that there has to be a railroad with them in that situation?
In this case, yes. And I don't know which of these two instituted the contract. But clearly, Canexus was a big player in that, and clearly Canexus did not try very hard to give voice to our preference for the short haul. Thank you.
Well, one more question.
Certainly.
Before, you've made the point several times that the record before us is incomplete in order to take into account other factors, because those other factors particularly are not spelled out very well, and that this case is fairly narrow in what's before us. We opened the rulemaking in order to decide what other factors we should consider in these routing decisions and what kind of weight we ought to give these various factors, and how should we interface with the the other agencies that have a role in this, including FRA. We opened a rulemaking. Do you think we could hold this case in abeyance? I know it's difficult because we have committed to resolving this case in the near future, but given the complexities and given the inadequacy of the record, as you have stated, would it be appropriate for us to open a rulemaking in this case and gather information that could be used both for this case and for subsequent cases as what kind of things we're going to take into consideration, what kind of factors should we take into consideration, including public interest factors and, as I said before, distance, population, exposure, and all of that, in making a decision as to what would be the appropriate routing. Because, quite frankly, I really feel that if this case goes forward to make a decision one way or the other, it's probably going to be the first of many cases along these lines as every railroad tries to short haul itself with regard to TIH movements.
But I could not endorse holding this case in abeyance if the consequence was that the status quo prevails, because basically that means BNSF loses for as long as the interval continues, and we all know that if there's a rulemaking, that could be a long, long time. And
the board moves very, very quickly on. Never mind. We would like to move quickly, obviously, but I understand your point. Yeah.
Thank you, Chairman, Vice Chairman Mulvey. Thank you, Chairman Elliott.
Thank you, Mr.
Sipe. A few points. First of all, I don't believe that I'm the only one who thinks it's peculiar that BNSF would end its remarks with a plea to not let the shipper dictate to the railroads what the route is going to be, a point it makes repeatedly in its filings. And yet, when it's setting the stage for why what it did is reasonable and what UP is doing is unreasonable, it explains its framework. It says it explained the framework to Canexus, that Canexus agreed to the framework, and that it thought Canexus understood that Canexus's job was to tell UP what they were supposed to do, which was to agree to a Portland and Spokane interchange. How is that carrier to carrier? That is one carrier talking to the shipper, reaching an agreement on a framework to dictate to the other carrier what the route is going to be. But wait, isn't that what Mr. Sipe just told you would be a bad public policy result in this case? And he is right. That would be a bad public policy result. But that isn't what happened here. What happened here is BN made a change in its business strategy in order to implement that in the minority of destinations that Canexus wants to ship to. It needed to get the agreement of its connecting carriers to a new route, and it skipped that step. And when I go back and read the Central Power and Light decision, which Mr. Sipe was correct to point to, I see many references to the routing protections in 107.05A2 confer on each railroad the initial discretion to choose the route. I don't see anything in either of those decisions that gives the origin carrier an effective veto, and in fact, the right to bypass the connecting carrier altogether. Second point, Mr. Sipe claims that, well, BN's accepting the long haul for 70% of the traffic. But my understanding, listening to what he said carefully, my understanding is, yeah, that's for the stuff that it's local. Well, guess what? They have 100% of the haul. The long haul is the short haul because they take it from the time they get it to the time they deliver it to the local destination. There is no question of long haul, short haul. Finally, the contract rate or the existence of the contract is not controlling, but it is relevant and it is entitled to some weight. because one of the statutory factors in 107.05.02 is the efficiency, the adequacy, and the economics of the transportation. We submit the fact that there is a contract suggests that that Kansas City is in fact an efficient, adequate, and economical route for the transportation. Are we saying it needs to be that for all time? No, but it is entitled to some weight, if not controlling weight. And UP is entitled to a voice. We believe that the best rule that the board can deal with, because let's face it, decisions regarding TIH transportation are too important to leave to a simple rule. We believe that the best policy course the board can go with is to stress the importance of carriers reaching a rational agreement and being prepared to defend when they cannot reach an agreement why theirs is the superior choice. We think it would also help, frankly, if we got guidance regarding liability allocation and the ability of rates to recover extra costs for TIH.
Thank you. Mr. Wilcox?
Thank you. Just a few points on rebuttal. As Mr. Sipe mentioned, BNSF has reached out to Canexus. It was late last week, and there's a considerable amount of travel time involved, and we had the holiday weekend, so parties were not allowed to, or did not have time to really talk, and we look forward to this afternoon's session. So we appreciate Mr. Sipe's comments. A couple of points. In terms of long haul versus short haul, I wanted to point out one factual issue in terms of UP being hauling chlorine from Portland to California. That is part of so-called I-5 contracts through the BNSF, or excuse me, the UPSP merger. There is a condition where UP actually can be technically an originating carrier for certain for shippers in Canada. So they are, from a rate standpoint, an originating carrier. So, and Canexus has worked with the railroads. I think it's also it's in the record where Canexus has worked with the railroads in terms of trying to work with their long haul preference when possible. It's also in the record that Canexus tried to engage BNSF about the interchange point for these particular destinations.
Just so I understand, with respect to the originating carrier, and it being possibly UP as a result of, I guess, trackage rights. Yeah, can that occur in this instance? That UP
it only works for certain destinations under the UPSB merger, and those are California and some other states. It does not work for these destinations.
Okay. I just wanted to be clear.
Probably should not have brought that one up first. So, another factual point is the BNSF, Mr. Sipe mentioned that BNSF was a carrier for 70% of the long haul movements, and I'm told it's more along the lines of about 50%, and in fact maybe closer to 40% for at least Canexus traffic. In terms of the, we're talking about, choosing the interchange point and different factors, and the railroads choosing or deciding where they're going to interchange. What Canexus does not want to do is minimize the importance of the contract here. This is the contract is, these are not easy to come by, particularly for TIH. They're very valuable. It was an arm's length. It is an arm's length contract. BNSF was aware that it was being negotiated. That's in the record. And so, what Canexus wants to be sure to be clear that BNSF's actions here would negate the value of that contract if BNSF prevails. And it's going too far to say that Canexus says that this is conclusive, meaning we have a contract, therefore we win. We understand the standards from CPL in terms of selecting an interchange point, but we believe that the weight given to that contract should be more than what certainly what BNSF says, it's certainly not irrelevant, as the Vice Chairman pointed out, but we believe we concur with UP that it's relevant, but we also think the board in the FMC case went further, and we can argue about whether it's dicta or not, but the board did very pointedly say contracts have value, we need to not allow carriers to negate them, and it's the policy of Congress to encourage contracting. I'm sorry, sir.
That's okay. So what you're saying, based on the bottleneck decisions, is that the contract is a factor and not an automatic requirement that there be an interchange point there in Kansas City, or are you saying something different?
No, I think that it's the bottleneck rules. It is a factor. We believe it's a very strong factor if you have an established interchange point and you have a contract from that interchange point. The rules are clear that the board is the ultimate decider of whether the interchange point is appropriate.
Let me ask you a hypothetical here. Let's say Mr. Sipe and Ms. Wren head back into the corner and they decide, okay, we can pick an interchange point. Where does that leave you in the contract?
Well, UP is a signatory to a contract. They are bound to deliver, as of now, the Canexus cars from Kansas City to these destinations at certain rates and terms. If there was a deal made for another interchange point, then that would require either amendment of the contract or a new contract, and certainly Canexus would be involved in that. And Canexus is not indifferent to discussing alternatives, but they have a value. There is value to this contract, and they want to preserve that value. They don't want it to be negated by these decisions.
If they just decided they wouldn't negate it, would that put you in a position that you would have to go to that interchange point that they chose together?
Well, then you get into questions of breach of contract if UP is operating contrary to their obligations under that contract, and as Canexus as the other signatory doesn't agree to amending it, or say they decide to go to another interchange point, but then the rates go up, not proportionally but well beyond, then now you're losing the value of the contract you have presently.
Mr. Sipe made the point that the Canexus plant in Marshall was developed in order to take some of the traffic out of North Vancouver during the Olympic Games. Does Canexus have any plans now to shut that plant down and move them back to Vancouver and consolidate there because the games have been played?
As a matter of fact, that was another factual clarification I got, and that the Marshall was not all about the Olympics. It manages inventory from the North Vancouver plant, so it is used today, and I understand they ship about 60 cars out of that facility, so it is used.
Mr. Sipe expressed skepticism on if we were to hold this in abeyance while we open the rulemaking on this, and understandably so, because if we did that, the status quo would prevail for the length of the rulemaking, and when the board finally made its decision. Do you have any thoughts on whether or not a rulemaking is appropriate here, one that would take into account all of the factors that might be involved in deciding the appropriate interchange for TIH? I mean, I think we need to focus on TIH here because this is a very unusual case before us where the railroads are fighting not to get the long haul, and that is extremely unusual. So, and it does involve TIH shipments. So do you think it's appropriate for the board to develop a record on that upon which to make its decision, that there's not enough in the record, as Mr. Sipe suggests, for the board to make a decision on this, to make a decision that would be other than simply recognize the originating carrier's right to choose the routing?
Well, I think that this case can be decided on its merits and not affect a rulemaking, a future rulemaking. I think if the board decisions do that in terms of precedent all the time, I think that you also don't need to tie this into a greater rulemaking because there aren't that many facts to explore here, because you've got a situation where the rate or the route that Canexus is complaining about is established. Their chlorine moved from North Vancouver and Marshall through Kansas City to these destinations. It's been happening for over a year, and BNSF does not dispute this interchange. They don't dispute that it works, that it's efficient, and so I don't think you have a situation where you have that inquiry here. BNSF they don't want to from a business standpoint. So I don't know if that's quite the same inquiry you would have in the rulemaking. I guess in terms of from a complainant standpoint, we believe that the record supports a decision in Canexus' favor, and we'd like the board to proceed to a decision.
Well, one of the factors, of course, is that this is a movement of a material that, if there is an accident, could threaten the health and the lives of people who will be affected. Many years ago, when I was at the TRB, we had a study going on of the movement on spent nuclear materials. And what we were looking at was the quickest and safest way of moving it. And the choice was between sometimes the safest railroad, the best track, but would often go for heavily populated areas, versus routing around those populated areas, but then putting the materials over a longer route, over track that was less than the best FRA class track. So that would have raised the risk of the risk of an accident versus the risk of exposure. So obviously, for spent nuclear materials, there's Price-Anderson, so that problem has sort of been taken away. We don't have Price-Anderson in the case of TIH. Mm-hmm. Whether we should or not is a public policy decision that we can't make. But those would be some of the factors that you might want to consider as to what the proper routing would be. Would you agree with that there should be these factors taken into consideration, and the record before us right now does not include enough information on those factors?
Well, I'm not disputing those are the factors. I just don't think that this is the case to look at those factors. I think if in a larger rulemaking, perhaps it's appropriate, but I don't think you need to do it in the context of this case or hold this case in abeyance. The other point to raise is that, contrary to BNSF view on this, there are no alternatives to BNSF. It's very clear for movement of the material from North Vancouver and from Marshall to the UP interchange in Kansas City. It's very clear. CP made it very clear they're not an alternative. And CN, BNSF has mentioned CN. CN doesn't get to Kansas City. So in this particular case, BNSF is a true bottleneck carrier because there is no alternative to them. And so I don't think you need to do. I think you could do the analysis you're talking about and the inquiry without doing it in this case.
Mr. Stipe said that the reason they want to be treated as the originating carrier in this case, and he mentioned a number of factors, and he also said, and also Canexus is asking us to move it from Vancouver. Now, if Canexus were asking either CN or CP to move it from Vancouver, I mean, you could get to Kansas City in some form, just as you couldn't get there now with the BN-UP route.
Well, you can't use CN because they can't interchange with UP for the contract movement from Kansas City to the destinations, and we can't use CP because CP has no rates, and they have made it clear they're not going to provide any rates.
Well, so was more done than just an email to CP trying to get a rate?
Well, the record shows there was at least an email, there was a response from CP, and then further discussion from CP saying this is not a rate under Canadian law, and we are withdrawing this informal rate, and we're not giving you a formal rate.
Help me understand why, if Canexus asks BN to move it out of Vancouver, does BN have more of an obligation in Canada to move it than if Canexus asked CP to move it?
Well, I don't know that in terms of the obligation, I would say their obligation would be the same, but the reason CP was not asked in the first place is because it's a considerably longer movement. CP has never hauled this material to Kansas City, and the record shows that there were more H2UA areas, and it's just a more complicated, longer movement, and so they hadn't even asked in the past.
But I think that somehow the record's getting a little skewed in that when this case came to us, there was not a long record of BN bringing the product to Kansas City. There were 18 plus shipments. So I think that we need to not lose sight of that.
You mentioned CP, but the traffic is really originated by CN, correct?
Yes.
Vancouver. CN, last time I looked, does go to Chicago. Could the traffic go from North Vancouver to Chicago and then be interchanged in Chicago with the carrier that serves Kansas City?
Well, again, that's the contract that we have, that Canexus has, is from Kansas City.
Right. Okay.
You can unravel things and go back, but the Canexus is making decisions literally at the last minute for 2011 and negotiating with the two carriers who have hauled their chlorine for years, even though Kansas City may not have been used as much as others. These are the two carriers that they have used for many years wherever they go.
You mentioned earlier on, this is a little off the subject, but that Canexus primarily manufactures chlorine for use in water treatment plants. Does it ship for any other purpose, or is it almost 100% water treatment?
I do not know, but Mr. Cove does.
Oh, okay. I mean, the Chlorine Institute tells us that 93% of all manufactured goods in this country contain some chlorine in them, and that therefore chlorine is a widely used material, and it's not just for water treatment plants, albeit that is a major user of it, but one which is being substituted for over time. Yes, sir.
So to answer your question, and I don't have the statistics in front of me, but the majority of what we do is ship to water treatment, but that's not the only thing. So we also ship to a variety of other users, including pharmaceutical, PVC, et cetera, et cetera.
Okay, thank you.
Mr. Cove didn't expect this, but he's done well. Is that it?
Yes, thank you very much
very
for
much.
coming, for your excellent argument, and we'll take this matter under advisement, and we do encourage you to resolve this matter in your afternoon session. I think that is the best way to work this out, not having us decide it. So this meeting of the board is now adjourned. Thank you.